Hi professionals, this is CA Rohan R. Pingai. Welcome to my YouTube channel CA Rohan Pingai and welcome to the video series on indirect tax, what law says. Video 2, that is part 2. Let's directly start for the subject. Let me allow to share my screen. First case for today, Paraswa Parswanath versus Principal Commissioner CGST 2023 GSTL 413 Punjab and Haryana High Court, and date of order is 27th July 2023. Relevant section is section 74 subsection 1 of CGST Act 2017. Let's understand facts and issue of the case. Petitioner was engaged in trading of chemicals. Respondent searched the business premises of petitioner. Respondent informed to the petitioner that it was in possession of bogus invoices from the supplier without actual receipt of goods and had illegally availed ITC. Further, petitioner was forced to deposit tax amount on the same day and respondent didn't provide the copy of the statements recorded. On conclusion of such operations, neither show cause notice nor any order was provided to the petitioner. The petitioner requested to refund the amount deposited during the search. Thereafter, an order rejecting such a refund was issued by a respondent contending that deposits made voluntary. Being aggrieved, petitioner preferred a writ petition before the Honorable High Court. Punjab and Haryana High Court observed and held that amount deposited during the search amount deposited during the search cannot be retained by department if no proceedings were initiated under section 74 subsection 1 of the CGST Act. Further, it was held that the amount deposited during the search under stress doesn't amount to self-assessment or self-ascertainment as per the section 74 subsection 5 of CGST Act. Here, High Court have told that it was amount is deposited during the search under stress, then it is doesn't amount to the self-assessment or self-ascertainment. Thus, the petition was allowed in favor of the petitioner. Next case. TVL Raja Stores versus Assistant Commissioner Sales Tax 2023 77 GSTL 367 Madras High Court, and date of order is 11th August 2023. Relevant section is section 65 of the CGST Act 2017. Let's understand facts and issue of the case. Petitioner was a partnership firm registered under the GST Act 2017. It made an application before the department for closure of the business. An order was issued allowing the petitioner to close its business with effect from 31st March 2023. Subsequently, a notice was issued for conducting audit under Section 65 of CGST Act. Petitioner, being aggrieved, filed a writ petition before the Honorable High Court. Madras High Court observed and held that Section 65 of the CGST Act specifically states that audit can be conducted for any registered person for such period, for such frequency, and in such manner. Hence, unregistered persons are exempt from purview of the said section. Accordingly, impugn order was quashed. Next case. Kesoram Industries Limited versus Commissioner of Central Tax 2023 78 GSTL 291 Telangana High Court. Date of order is 28th September 2023 and relevant section is section 79 subsection 1 clause C of CGST Act 2017. Let's understand the facts and issue of the case. Petitioner was engaged in manufacture and supply of cement. A letter was issued to the petitioner demanding the interest on account of what delay in payment of tax. Petitioner was further instructed to discharge the interest liability within 7 days, failing which recovery proceedings would be initiated as per Section 79 of CGST Act 2017. Petitioner submitted two letters stating that they have already paid interest on delayed payment of tax dues. However, disregarding the submissions made by the petitioner, garnishee proceedings were initiated under Section 79, subsection 1, clause C of CGST Act 2017 without, without issuing any show cause notice or providing opportunity of being heard. Aggrieved by the same, a writ petition was filed before the Honorable High Court. Then Telangana High Court observed and held that the respondent had erred while initiating the impugned garnishee proceedings since neither any show cause notice under Section 73 or Section 74 of CGST Act of 2077 was issued, nor any opportunity of personal hearing was provided, resulting in breach of principles of natural justice. Thus, the impugned proceedings are liable to be set aside. Next, Praveen Bhaskaran versus Union of India 2023 79 GSTL 210 Kerala High Court. Date of order 20th September 2023. Let's understand facts and issue of the case. ITC claimed by petitioner was denied by an order on the ground that ITC was not reflected in GSTR. This is very, very important case, my friends. Please note it down. The fact is, ITC claimed by petitioner was denied by an order on the ground that ITC was not reflected in GSTR2A since the supplier of petitioner had not mentioned supplies while filing GSTR1. This we face regularly. This is the regular issue and very critical. So please note down this case law and study for your future reference. Also, no proof of payment of GST to the department was provided by the petitioner. Aggrieved, a read petition was filed before the Honorable High Court. Kerala High Court observed and held that ITC cannot be denied merely because it is not appearing in GSTR2A of petitioner. What High Court is observed and held that ITC cannot be denied merely because it is not appearing in GSTR2A of petitioner. So reasonable opportunity should be provided to the taxpayer for submitting evidences, and ITC should be allowed if the claims were bona fide and genuine. Impugn order for denial of ITC was thus set aside and matter was remanded back to the respondent for examining the evidences. So it is very important case law for all of us. Next, Ma Kamyaka Trader versus State of UP 2024 80 GSTL 39 Allahabad High Court, date of order 16 October 2023 and relevant section is section 129 subsection 3 of CGST Act 2017. Let's understand facts and issue of the case. Petitioner vehicle was intercepted. It was found that an e-way bill and e-invoice of an incorrect product with different values were produced by the transporter on inspection. As a result, an order for detention was issued and notice was issued demanding tax and penalty. aggrieved, a read petition was filed by the petitioner before the Honorable High Court on the grounds that the notice issued under Section 129, subsection 3, demanding both tax and penalty was not appropriate. What Allahabad High Court observed and held that the impugned order was to be quashed since the same was based on an invalid notice demanding tax as well as penalty. Next case. Technosis Security Systems Private Limited versus Commissioner of Commercial Taxes, Indore 2024 80 GSTL 4, Madhya Pradesh. Date of order 5th December 2023, and relevant section is section 75, subsection 4 of CGST Act 2017. Let's understand facts and issue of the case. Petitioner was issued show cause notices in two different cases. Petitioner was issued show cause notices in two different cases. Subsequently, to the reply filed for the same show cause notices, final orders quantifying tax, interest, and penalty were issued without providing opportunity for personal hearing and in violation of principles of natural justice mandated as per section 75, subsection 4 of CGST Act 2007. Aggrieved, a petition was filed before the Honorable High Court. Madhya Pradesh High Court observed and held that the contention of the respondent that section 75, subsection 4 of the Act uses the term opportunity of hearing and the word personal is missing. Hence, filing a reply to show cause notice amounts to an opportunity of hearing was not sustainable. Section 75, subsection 4 of CGST Act 2017 clearly specifies that opportunity of hearing should be granted where there is a specific request in writing or where any adverse decision is contemplated. Since no opportunity for a personal hearing was granted, impugned orders were liable to set aside. Next is Abilities Pistons and Rings Limited versus Additional Commissioner Circle 2 appealed Commercial Tax 2024 159 taxman.com 326 Allahabad High Court. Date of order 6th February 2024. Let's understand facts and issue of the case. Goods were imported from China and IGST at the rate of 28% was paid at the time of import. The invoice and e-way bill were accompanying the goods and the description of the goods matched with the invoice. However, Part B of the e-way bill found not filled up at the time of interception. The petitioner filled up the particulars in Part B immediately after the interception. Therefore, the petitioner prayed that the intent for evasion of tax was upset. So, Allahabad High Court observed and held that there was only technical fault with regard to the non-filing up of Part B of the e-way bill. IGST was already paid and no mensory was present on the part of the petitioner. So, that's what today we will stop here. So I think this video on case laws helping to you to update yourself, because what as a professional will lack in updating ourselves day by day. So it is my humble endeavor to update you through this video series. So you updated for day-to-day basis on whatever case laws will help you in your litigation practice. So that's it for today. We'll meet in next video. Till then, see you soon.